The Constitution of India grants its citizens the right to freedom of movement. This means citizens of India can move freely throughout India. If we want to go to Shimla, we are free to go. No one can stop us. If we want to go to Chennai, no one can stop us. We don't need to take any permission from anyone to move anywhere within India. But if someone tries to stop us from going somewhere, or if someone obstructs our way to prevent us from reaching a place where we want to go, then it is not only violative of our constitutional rights, but also a criminal offence under the Indian Penal Code. Yes, Section 339 talks about wrongful restraint. The definition under this section says, whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. So from this definition, it is clear that restraining someone is not a crime, but wrongfully restraining a person is a crime. And what is wrongful restraint? Wrongful restraint basically means stopping a person from going to any direction where he has a right to go. So basically, to charge a person under this section, two things need to be proved. First, a person must obstruct voluntarily. This means the person must knowingly restrain the other person. For example, if a person parks his car in front of your car in such a way that you cannot take out your car, then this is of course bad parking manners, but it will not amount to offence under this section because he had no intention to prevent you from going somewhere. Second condition, the obstruction must be such which prevents a person from proceeding in a direction in which he has a right to move. Imagine you're going to your home from office in the evening in your car, but a person blocks the road and asks you to take another route for your home because his son's marriage procession is going from that road. This will amount to wrongful restraint because you have the right to go from that route and the other person is stopping you from doing so without any justifiable cause. So these were the two conditions to charge a person under section 339. Now this section has an exception appended to it. This exception says the obstruction of a private way over land or water which a person in good faith believes himself to have a lawful right to obstruct is not an offence within the meaning of this section. This basically means if a person believes in good faith that he has the right to obstruct the way of the other person, then it will not amount to wrongful restraint, and such person cannot be charged with section 339. For example, a person is organizing a family function in a park. He obstructs other persons from entering into the park, saying that he has obtained necessary permissions to use the park for his family function. However, later it was found that approval was pending because the requisite fees was not paid. So here if the person believed that the fees was paid and he had necessary approvals, though in reality he did not have the approval, then he will get the defense of this exception. Let's look at some examples and see what amounts to wrongful restraint and what doesn't. You buy a movie ticket, but at the entrance of the cinema hall, the security guard stops you. This is wrongful restraint because as soon as you buy the tickets, you become entitled to enter the cinema hall. Second, parents restricting the child from going out to play. This is not wrongful restraint. Till the time child does not attain the age of 18 years, the parents have the right to impose restraint on the child. Third situation, a landlord asks the tenant to vacate his house, but the tenant refuses to vacate the house. One day, when the tenant goes out for work and when he comes back, the landlord obstructs his entry to the house. This will amount to wrongful restraint because even though the landlord is the owner of the house and he has the right to ask the tenant to vacate his house, but he has to do it the legal way. If the tenant refuses to vacate the house, the landlord needs to go to the court and have the tenant vacate the house. But obstructing the way of the tenant to prevent him from entering the house will amount to wrongful restraint. Fourth situation, a person's way is obstructed because the road was closed due to construction. This is not wrongful restraint, as the road was closed by the construction company to prevent any mishappening due to the construction work. Fifth situation, in Delhi, some roads are closed for public few days before the Republic Day. Now one cannot claim that this is wrongful restraint as the roads are blocked in good faith for the purpose of security and preparation of an event which is of national importance. Sixth, if a person is not allowed to go out of jail, then it will not be wrongful restraint because a prisoner is supposed to be in jail only and has no right to go out. But if such prisoner gets bail or parole, then he has the right to go out of the jail, and if anyone prevents him from going out of the jail, he will be guilty of wrongful restraint under section 339. Alright, so from these examples, it is clear that any obstruction caused in good faith will not amount to wrongful restraint. Now let's look at some important points relating to wrongful restraint. In wrongful restraint, it is not necessary that the movement must be stopped completely. Even if a person is diverged from the direction he intends to go in to another direction, it will amount to wrongful restraint. Second, physical presence of the accused is not necessary to obstruct the way. Offense can be committed even when the obstructor is not present. For example, if a person threatens another person not to use a particular way for his commute, it will amount to wrongful restraint, because even though there is no obstruction on the way, the person will not use the way because of fear of threat. Right? Third, the offense under section 339 is committed by the effect caused by the act and not by the nature of the act. For example, if a person removed the ladder which caused the person to get stuck on the roof, then it will amount to wrongful restraint. The accused cannot say that he only removed the ladder and did not obstruct the path of the victim. The removal of ladder has the effect of detaining the victim on the roof, and hence it will amount to wrongful restraint. Now coming on to the punishment for this offense, the punishment for wrongful restraint is contained under section 341. Wrongful restraint is an offense, but it is not that serious offense. Therefore, the punishment is light as compared to other serious offenses. Section 341 prescribes imprisonment up to 1 year, a fine, or 500 rupees, or both. The offense is cognizable, bailable, triable by the magistrate, and compoundable by the person restrained. So this was all about wrongful restraint. Let's move to wrongful confinement in the next lecture. So see you there.